We are not impressed, not in the least.
The ICC pre-trial chamber judges dismayed by what they see as a complete disregard of one of the rules they gave at the onset of this trial, that all and sundry should refrain from media commentary about the case.
Our attention has been drawn to the unending stream of clamor in the Kenyan media about the proceedings in this case.
Ordinarily, comments made in the context of an active trial amount to sub judice. The judges are perturbed by this conduct they say they observed even before the trial began.
We have been praying each of us separately.
Several matters arising from the ongoing trial have been at the center of political debate, including the recent decision allowing the prosecution to use prior recorded statements of witnesses who recanted their evidence. The latest sensation being Gatundu South MP Moses Kuria's revelations about the genesis of this case.
Even abusive commentaries have been directed at the court and the judges when judicial decisions have been issued that has not been or have not been to the liking of those making those commentaries. Of course, in an apparent hope of bullying judges into the groove of these sentiments.
The bench reiterating that its discretion will be based only on the evidence and the law.
Clamor in the media will remain wholly without effect in the outcome of the case, so we must encourage those concerned in the conduct to save themselves the trouble, for the only thing they achieve in the clamor is to shore up the imperviousness of the chamber to them. We'll leave it at that for now and hope that people will leave this case alone and let the judges and the lawyers in the case do their work.
Presiding Judge Osuji made the remarks during the hearing of submissions on the prosecution's application to recharacterize Sang's charges.
The prosecution was not reasonably in a position to make the request until it was able to fully assess the evidence on record, including the evidence that was the subject of the Rule 68 request.
Trigger is a better word.
The effect of the application by the prosecution amounts to conceding that it is possible that the defense were always right, that in fact the network did not exist. However, we still have to catch you, and we will catch you even outside the existence of a network, which he had noticed as being what he was coming to answer.
The defense argues the application is prejudicial to Sang. Sylvie Chebet, Citizen Weekend.